Good afternoon. My name is Isabel Montoya Minesey, and I, along with Mr. E. Patrick Hill and Ms. Joan Marie Sullivan, represent Lee Marshall and the Kids to Love organization. I would like to start out by giving you a brief history of how we got to this point. On June the 15th, Kids to Love received an email from Karen Smith, Deputy Commissioner of Children and Family Services, alleging confidentiality violations, but not stating anything specific with regard to what was violating confidentiality. That same day, unbeknownst to Kids to Love and Lee Marshall, Amanda Mancuso, Director of Children and Family Services, sent an internal memo to all 67 DHR county directors notifying them that all placement referrals to Kids to Love programs was immediately suspended. The memo CC'd Nancy Buckner, the Governor's Commissioner of DHR, Ms. Karen Smith, Deputy Commissioner of Children and Family Services, and Shay Cobb England, Deputy Commissioner of Quality. The memo did not give a reason for the suspension. On June the 16th, the next day, Lee Marshall responded by letter explaining that all of the children posted on the Kids to Love website were posted in hopes of finding adoptive families for them, that they were posted through a confidentiality agreement that dated back to 1999, whereby the organization was posting children's photos with their biographical information through a partnership with DHR. And through that partnership was able to find over 300 families for children in care. On June 19th, I called DHR State Legal and informed them that we were aware of the suspension of referrals, that it was done in violation of due process, and requested that the suspension be immediately lifted and that they give the reasons for the suspension, if there were any deficiencies, a list of what those were, and a time frame for remedy. The department did not respond. Later that day, I followed that up with a letter requesting the same. That same day, DHR sent a team out to do an inspection of all Kids to Love facilities and Kids to Love files. On June 20th, Kids to Love received a letter from Shay Cobb England and Karen Smith alleging several violations of the minimum standards for child placing agencies. At that time, we made the decision to wait for DHR's inspection report on the review of Kids to Love facilities and files. However, on July 13th, I received an email from Chief Legal Counsel for DHR, Felicia Brooks, that included a redacted court order from a juvenile court stating that Kids to Love was in violation of confidentiality regarding a child on the website, and that all DHR's efforts to have Kids to Love remove the information were to no avail, requiring this court order. This was the first time in all the multiple requests that we had made to DHR about what information was violating confidentiality and what information they wanted removed, that we finally had two initials of a child and were able to identify that child and within 5 minutes remove that information from the website. Because the court order was redacted, it took a while to find out where we could file a response, which we did on July the 25th, clarifying to the court that DHR, not Kids to Love, drafted the biographical information that was posted with the child's photo, and that the information was posted pursuant to confidentiality agreements to do such postings. We also submitted the multiple requests that we had made to DHR requesting what information they wanted removed, which were ignored. On July the 26th, DHR responded to our clarification to the juvenile court by retaliating against Lee Marshall and the Kids to Love organization by rescinding the confidentiality agreements that were the impetus for Kids to Love organization to start in the first place. Now, if you all recall, Ms. Marshall used to be a news anchor, and pursuant to these confidentiality agreements, she had a partnership with DHR that dated back to 1999 to find forever families for these children. And on this day, they rescinded those confidentiality agreements, ending decades-long partnership of Finding Forever Families. Immediately, Kids to Love removed all information of children on the website. In July, we also received DHR's inspection report from the inspection that had been done in June, which stated that Kids to Love had 0 deficiencies and no corrective action was needed. On July 28th, we sent another letter to Ms. Buckner, Ms. Cobb-England, Ms. Smith, and Ms. Mancuso, requesting that the suspension be lifted and forwarding the inspection report. Again, there was no response. On September the 6th, we sent our final and 4th request to have the suspension lifted and requested that if it was not lifted, we would like to have an administrative hearing. September 7th, almost 3 months after the suspension of referrals was put in place, we received our first response from the department from Ms. Felicia Brooks of Chief Legal Counsel for DHR, who stated that our request would be considered. On September 10th, DHR attempted to remove 2 of the children that were placed in the Kids to Love foster home, but stated to the foster family that if they would move their licensing from Kids to Love to DHR, they would not remove the children. At that time, we filed for a temporary restraining order at the Circuit Court of Madison County, evidencing everything that I have just stated to you. We were granted that temporary restraining order on that day, prohibiting the Department of Human Resources from removing children from Kids to Love foster homes and placements, barring safety or harm to a child. After various motions were filed thereafter, DHR filed a petition for a writ of mandamus with the Court of Appeals, along with a motion for an emergency stay of the temporary restraining order. They subsequently withdrew their motion for a stay of the temporary restraining order, and the Court of Appeals forwarded their petition for a writ of mandamus to the Alabama Supreme Court. That petition argued that the trial court did not have jurisdiction over this case. Attorney Joan Marie Sullivan submitted our response to their petition on Tuesday of this week. And yesterday, DHR attempted to withdraw their petition at the 12th hour. Nevertheless, without addressing DHR's motion, our Supreme Court issued a unanimous decision denying DHR's petition for mandamus relief, notwithstanding Judge Wise's recusal. At this point, we look forward to moving forward with our case at the trial court level and seeking relief there. There are a few clarifications that I would like to make. First, while we can't address many of the allegations lodged against Lee Marshall and Kids to Love by Ms. England and Ms. Smith, what I can tell you, after having reviewed all of the documentation, and let me tell you, this organization keeps meticulous documentation and has throughout the years. After reviewing hundreds of pages of documentation, I can tell you that nothing in the allegations violates the law or policy. Lee and the organization are guilty of advocating passionately for the children and the foster families in their care, and nothing more. Second, the defendants have engaged in misleading information regarding these allegations. One example that I would like to point out to you is the one that I spoke of earlier with the case where they filed a motion for protective order in a juvenile court alleging confidentiality of violations and that their many efforts to have us remove the information had gone to no avail. That is untrue. We had requested many times what information they wanted removed. Our requests for information were ignored. And third, and I want to be very clear about this, our contention is with the named persons in the lawsuit and the people that I have already named. This is at the state level of DHR. None of this situation involves the local county directors, supervisors, or social workers who are in the trenches every day to serve our children, to protect our children, and to serve the families. On a personal note, on behalf of our legal team, I can tell you that we are honored to represent Lee Marshall and Kids to Love. I've actually served in one capacity or another children in foster care in this county for the last 20 years as well. My path and Lee's has never had opportunity to cross until June of this year. And I have been nothing short of astounded at not only the remarkability of this organization, the services they provide to children in foster care, to their families, to the foster families, and to our counties in general and our state. It is remarkable. The level of integrity, excellence, and transparency that this organization operates in is second to none and has made our job much easier. I've witnessed the tears, the anguish, and the prayers of Lee and her team through these past several months, and there have been many, and understandably so. She's built her life, and her team has put their whole heart into building this organization. At this point, we've made several requests to meet with the other side in hopes of a mutual resolution to this situation. As of mine and Mr. Hill's last conversation with Felicia Brooks, Chief Legal Counsel for DHR, requesting a meeting to discuss settlement of these issues, their position was that there was nothing to discuss. We hope that position changes and resolution can be had. Alternatively, Lee has called on Governor Ivey to open our homes back up to the children in foster care, which she has the power to do. If she chooses not to, we look forward to pursuing that remedy through the courts. Thank you. We're open for questions if you have any. Yes.
Were all children under Kids to Love care transitioned over to DHR, or are there still some that were kind of left in limbo?
No, we have the temporary restraining order that prohibited them from moving children barring safety concerns or harm. So those children are remaining with that foster family, which we're really happy about. There was no reason to re-traumatize them with an unnecessary move. So we're glad that the court acted swiftly to prevent that from happening. So that has not happened at this time.
What is a Kids to Love affiliated foster home? And what would it mean to make that DHR?
So when a family chooses to foster children, there's a process by which they must be licensed, and it's a rigorous process of background checks and trainings and home inspections, things of that nature. There are agencies that are licensed to license foster families, which Kids to Love is one. So some families don't want to be licensed with the department for various reasons. And so they have the option to be licensed through other agencies like Kids to Love. And so Kids to Love does the trainings, the background checks, the home studies, everything that needs to be done to make sure that these homes are safe placements for our children in care.
Has there been any accusations that Kids to Love has been deficient in that process?
None. There have been none.
What is your case at this point? It looks like the court has sealed the complaint without getting into areas that the court feels are too sensitive. Can you characterize what it is you're seeking in court at this point? I know the temporary restraining order is in place, as I understand it, but you're asking for more than that. Can you clarify what you're talking about there?
Yes. So we are asking in their official capacities for injunctive relief, and we want permanent injunctive relief. And so that would look like lifting the suspension of referrals immediately so that the county directors who want to work with the organization, who have still been calling to try to place children with our foster families, with Davidson Farms, with our organization, are free to do that and serve the children in their care. That's the first and foremost thing that we want done, is the suspension of referrals to be lifted. Secondary, there have been allegations made that are misleading, that are untrue, And so we want a correction of all of that to the public and to whoever the statements have been made to, that this organization has operated in nothing less than integrity in their operations, in all operations. And then we're seeking, we have tort claims against these individuals in their individual capacities for knowingly violating policy and law by implementing this suspension on referrals. Yes.
Throughout this whole process, have they given you any pathway to continue your work? Because I'm sure they know that there is a foster care crisis in the state. Did they give you any pathway with these complaints?
They have not. And what I will tell you about that is this organization, from the video that you just watched, serves children in care on such a broad level. I can't even begin to tell you all the services that they provide. They provide the Christmas gifts. I mean, extreme Christmas gifts for these children in care, for thousands of children. They provide the backpacks and the school supplies. They have the K-Tech training facility that certifies children that are aging out of foster care, need careers, helps them get certified, and helps them, sets up interviews for them with local organizations so that they can start careers and get jobs. They have Davidson Farms, they have the foster families. There are so many services that they do. So there are some that they can still engage in, providing emergency relief and supplies to foster parents, which they do to all foster families, not just Kids to Love foster families. Foster families can call the Kids to Love organization with emergency needs for the children. The organization fulfills those needs. So with regard to all of those services, those will move forward as they always have. Where we are restricted right now is that the county directors have been restricted from placing referrals of children in our facilities, and that is what we need remedied immediately. And let me be clear about another thing. There is no policy for a suspension of referrals in DHR policy. There is no governing policy for suspension of referrals. They have suspended referrals so that we have no administrative remedy. They will not suspend the license. They have not suspended Kids to Love's licenses, because then we would be entitled to an administrative hearing and an administrative process, and there is policy that governs a suspension of a license. There is no DHR policy by which the department can implement a suspension of referrals or that governs that process.
Court cases take time. You guys know that better than we do. The sort of existential threat to the operations this facility this organization seem fairly pointed at this point. Do you have any confidence that if Judge Pate goes ahead and sets a hearing, the timetable that a normal civil case takes seems pretty different than the sort of timeline that you're looking to be on? What steps can you take in regard to that to speed up a process where it seems like the other party has no interest in speeding up anything?
That's not the other party's decision to do anything, so we will be moving forward. We assume that the judge will schedule our hearing for preliminary injunctive relief, and that hearing will be had very soon. That hearing, we fully expect to be able to prove to the court that the suspension on referrals should be lifted, and we expect that that suspension of referrals will be lifted at a preliminary injunctive hearing. Further than that, though, there is not an existential threat to this organization with regard to serving children in foster care and having placements placed in our foster homes and the Davidson Farms facilities. The law provides that judges, once they have deemed a child dependent, can place that child not only through DHR, but can place through agencies such as Kids to Love. The courts and the judges of this state do not have to place through DHR with Kids to Love, and we think they're starting to recognize that.
Well, under the temporary restraining order, why would it not lift the suspension on referral?
The temporary restraining order was meant to be put in place for a limited amount of time, 10 days, longer if there was good cause shown. at which time there would be a hearing for preliminary injunctive relief. Because the department decided to file their petition for writ of mandamus and their motion for an emergency stay, that has pushed that process out. But with the Alabama Supreme Court's decision yesterday denying their petition for mandamus relief, that brings us to the trial court, and we can move forward immediately with our hearing for preliminary relief.
Has the PRO expired?
It has not.
Okay. But it was never in place to lift the suspensions.
It was not. That will be done, we anticipate, post preliminary injunctive hearing. If that's all, we thank you all for coming. Oh.
Sorry, I didn't know if Ms. Marshall wanted to take any questions or help us or.
I can take some questions.
Talking about the future of the organization, but rather than me ask you about it, how do you see Kids to Love moving forward? How are you going to operate? What are your plans?
I think Kids to Love stands strong in our community. I think you saw the video of the community that stands with us. I'm honored to have several of our board members here today. The thing that sets Kids to Love apart that I think is a key piece that has not been addressed here today is that we do not take state or federal funding. We run an operation that is completely debt-free. Outside the licensure of the Child Placing Agency or the licensure of Davidson Farms, DHR has no say over our services. K-Tech is an independently run, licensed private school under the Alabama Community College system. We will continue to support foster families as children come into care. Just yesterday, we had multiple children that we provided emergency assistance for because we are here to serve the children. Christmas gifts will go on. Our kids depend on us for Christmas, and we have a warehouse right now where more than 2,000 lists are being filled. I think it shows a testament to our commitment of service that while our organization is committed to do what we need to do to fight for the right of every child in foster care to have a loving home, we also are not stopping our service, which is the heart of who we are and what we do. So this will not stop our organization whatsoever. We still have children placed at Davidson Farms. We still have children placed in our foster homes. There are other ways for us to have children placed, as Isabel mentioned, either through the court system or private placements. And those both have recently happened, I would say, within the last 6 months. So our service will continue. The tragedy here today is there are over 6,000 kids in foster care and just 2,300 licensed foster homes. DHR consistently recruits for more foster families. We have amazing foster families that have empty bedrooms that are just waiting to stand up and say, we'll welcome these children home. This is 100% about the children being tokens in the middle of this, and the children are the ones that are suffering. So we are calling on the court system. We are calling on the governor to open our homes because children should not be used as pawns in this. And that's exactly what's happening. Kids to Love will continue to serve. 19 years, we've had a direct impact on the lives of more than 300,000 children. You saw in the video, we gave out a little bit of a new news that we haven't even publicly shared yet. Last week, we were recently received our license to be a child placing agency in the state of Tennessee and to do private adoption there. So we will continue to serve children that need us in foster care, and we are thankful to have a community that will stand behind us. And we are thankful that the Alabama Supreme Court sent a strong message to DHR because they have operated above the law, and it's time our children have a voice.
Okay, one more. What do you think's animating this conflict? Why do we find ourselves here now?
To my knowledge, we are the only agency in the state of Alabama that does not take money from DHR. With money comes control. I have done everything within my power since December to avoid filing a lawsuit, to avoid bringing the media in. And if anybody understands the power of the media, it's me. I sat on the lawsuit long after Isabel was ready to go with it. But to me, it's unfortunately about egos at the state office and control, and none of it is focused on serving children. And that is a crisis.
I do have one other question for you. I guess, how does it feel with your personal connection to the foster care system, seeing how this is kind of all playing out with DHR? How do you feel?
I can tell you the whole reason we started Kids to Love was because of my personal journey of being born into foster care and thankful to be adopted. But what I have the unique perspective to see are the children that we get to help every single day. Kids that don't have a voice. Kids that don't have an advocate. Kids that go into ISP meetings, the individual service plans, and they need assessing, they need diagnosing, they need treatment, and nobody's there to fight for them. They don't have a voice. So to me, we say we passionately advocate. DHR views that as interfering. We will continue to passionately advocate for all children in foster care in the state of Alabama because they deserve a voice. Thank you so much for your time.